morning.
Good morning.
Morning, all. Today is February 10th, the court day of the hearing in the matter of docket number 4550. With me online today.
I'm sorry to interrupt you, but anyone who is listening to this hearing, if you can please mute yourself. It looks like someone is on a cell phone who hasn't muted themselves.
Right hand.
Okay.
All right.
Thank you.
With me today for the board is member Michelle Phelps, who is online on the screen. On my right, member Gwenna Peters, and I am David Belanger. I'll chair the hearing today, and we're going to begin with the state's case.
Before the state calls a witness, we had an exhibit that was sent around to the parties that we'd like entered if it could be stipulated to. That's exhibit proposed 64, which is the transcript of the May 4th, 2023 House Corrections and Institutions.
And the state would agree to stipulate that.
We all have it.
The exhibit number?
64.
Thank you. And the state's going to call Jared Foster to stand. He is waiting. Thank you. There's water here for you too.
Oh, thank you.
Morning.
Morning.
I have an oath for you to be sworn in. You solemnly swear or affirm under pains of penalty or perjury that the testimony you shall give relative to the cause now under consideration shall be the truth, the whole truth, and nothing but.
Yes.
Thank you. Welcome.
Could you please state your name for the record?
Jaron Foster,
And who is your employer?
State of Vermont Department of Human Resources.
And how long have you worked for the state?
I've worked with Human Resources for 10 years and the state for about 12 and a half years.
And what is your current position with the state?
I am a financial and report analyst.
And how long have you been in that position?
Officially about 3 months, but I've been in the reporting division for the full 10 years that I've been with the department. There was just a change of responsibilities recently, some additional responsibilities came with a job title change.
And so what are your responsibilities sort of generally in your current role?
There is primarily, there's federal reporting. We assist departments across the state with providing data within our VTHR system and generally assisting with data related requests within the department and statewide.
And did you also have those responsibilities prior to the title change to financial and report analyst?
Yes, I did.
And what was your title previously?
It was compliance and report analyst.
Could you please turn to exhibit F as in Frank in your exhibit binder in front of you there?
Yes.
Are you familiar with the state's telework policy, which is policy number 11.9.
Yes, I am.
If you could turn to, so it's marked in the upper right-hand corner, exhibit F, 0016.
Yes,
And that's, on the top of that page, it says telework request form.
yes.
And are you at least generally familiar with this telework request form that's part of this telework policy?
Yes.
Could you now turn to exhibit YY? Why is it yes? And do you recognize this document, Mr. Foster?
Yes, I do.
And what is it?
This is a data list of employee information that was submitted via the previously mentioned telework request form. This is an export from SharePoint that includes the exported fields from the form itself.
How do you know that's what it is?
I have, so in my role, I was requested to take the data that was submitted by the employees in the form, and it was listed in this format. So I have seen exports of this data before.
And did you create the export that turned into this document?
Yes, I did.
And can you just very briefly and generally describe the process when we're to do that?
Yes. At what point would you like me to be in? So the process in which I exported the file?
Yes, generally.
Generally, okay. So I had access to the database in which this data was maintained. And I was able to, it's a functionality within the software to export it to Excel in this format.
And could you just briefly walk us through some of the columns on the
Yes.
form? So the first column says title.
Yes.
That.
So the title is the employee's name.
Second column says employee. What is that?
So that is the employee's name as is listed in our VTHR database.
What is the VTHR database?
So that is the platform on which statewide data rests, and that we can retrieve data for various data requests. It is the system that employees are familiar with because they enter their time into the VTHR system. And so the second column, employee, is the format in which it is stored in that system.
And the third column says agency.
Yes, that is the department or agency in which that employee works.
And is that was that information submitted by the employee, or did it come from a different system like VTHR?
That information was, that particular field was entered by the employee.
The next column says department. What is that?
Okay. So in some cases, the state has, it's the agency at the top level, and in others, it's the department listed at the top level. If the agency, if the record that's listed for the agency is actually an agency as opposed to a department, then the department underneath is the department within that agency.
And that's information that's entered by the employee.
Correct.
And then the next column is number of hours per week. Do you know what that signifies?
That is the number of hours that the employee identified they would be working remotely and not in the office.
Then what is the next column, ID?
That is a automatically generated field to be able to identify that particular record in the spreadsheet.
Then the next column, it says created, as looks like dates and times. What is that?
Yes, that is a timestamp on which the form was submitted to the state.
Then the next column is round trip commuting miles. Was this information entered by the employee?
Yes, this was entered by the employee.
And in the next column is transportation mode. Was that also information entered by the employee?
Yes, it was.
And the next column says employee email. Did the employee submit this information or did it come from another source?
That field was exported from the VTHR database in the same manner as the second column, employee.
And then the next column says status, and there's active and inactive. What is that? What does that information mean?
So at the time that this particular spreadsheet was exported, that indicates whether that employee was an active employee with the state of Vermont.
So that's not something the individual employee entered themselves.
Correct.
And then the next column says item type, and all the entries appear to be item. Do you know what that means?
That is a default field that is exported with the spreadsheet. That was not entered by the employee.
And then the final column is path, and it looks like all the paths are Teams/DHR-telework/list/telework. What does that mean?
That is the SharePoint URL. That is the SharePoint website address in which all of these forms reside.
And so if I'm understanding correctly, so this information was the columns we talked about being entered by the employee, that was entered, was that in a spreadsheet that looked like this? Was it a form that was created?
It was entered into a Microsoft form in a user-friendly format. And then once submitted, the data was then sent into this SharePoint list in this format.
And did that user-friendly Microsoft form, did it ask the employee to upload any documents with the entries of those various fields we talked about?
Yes, it did. And the attachments were included with the records within the SharePoint list.
All right, could you please take a look at the exhibits that are under tabs ZZ as in zoo through OOO? do you recognize these documents?
Yes, I do.
And are these documents that employees, who are reflected on the spreadsheet we just talked about, are these documents that, they uploaded?
Yes, that is correct.
And that's to the sort of telework SharePoint you talked about?
Yes.
And how do you know that?
I have reviewed these and validated that they correspond with the data that was exported from the SharePoint list.
And where, these forms live, and where are they kept?
They are maintained within a secure SharePoint list that is accessed by limited staff within the Department of Human Resources.
And, can I ask you, are these true and accurate copies of what was submitted by employees on that spreadsheet?
Yes, they are.
All right, thank you, Ms. Foster. Those are all my questions.
Thank you.
I'm sorry, before he does, I'm just wondering if we can get a little bit more kind of foundational and basic. So when you talk about it's stored on the SharePoint site, could you just, for members who, or folks who may not appreciate what that is,
Yes.
explain that a little bit more?
Absolutely. So SharePoint is a Microsoft program. So the state uses Microsoft Office Suite, which includes Excel, Word. SharePoint is one of the platforms that is available to us as a tool. And it is commonly used to maintain data within lists and easily allow us to track information and export information.
Okay, thank you.
Hey there.
Hi.
Are you okay if I call you Karen?
Yes.
Okay, I'm Catherine Terrell, and I'm counsel for VSEA. So I'm asking a few questions.
Yes.
First of all, do you yourself telecommute?
Yes, I do.
Okay, and
You're
you're,
object, that's outside the scope of the direct.
all of them, withdraw option. Yeah, I just, let me not withdraw that question actually, because he in fact appears in the records that we were just, that, am I wrong? Is there another employee with your name, if you know?
Not that I am aware of.
Okay, well, so I'll, there's a little numbering in the pages here. It's called bait stamping. Are you familiar with that?
No, I'm not.
An exhibit YY. And if so, so you see, there's like little numbers that appear in the corner, 000, and so we're looking for 00514. Six from the bottom. Thank you.
Is that Evan Welsh?
7 from the bottom. 7 from the bottom.
Oh, yes.
Thank you. See it?
Yes.
Okay, and so do you know if that's you?
Yes.
Okay, so you in fact do telecommute as well, and it's reflected in these documents.
Yes.
And has your telecommuting changed recently?
Yes.
Okay. When did you generate this document?
This was generated on October 13th, 2021.
Okay, and who directed you to compile this document?
Objection. for any, to the extent it invades on attorney-client privilege or the work product.
That's fine, to the extent that it does.
I'm sorry, can you repeat the question?
So unless it was your attorney, unless it was the state's attorney, can you tell me who directed you to compile this list?
I believe it would have been my supervisor.
Okay, and who's your supervisor?
It was Harold Schwartz.
And what is Mr. Schwartz's job title?
He has retired, but he was the director of operations for the Department of Human Resources.
And who took over that role?
It is currently vacant.
And did Director Schwartz tell you what the purpose of this compiling this document was?
It was to comply with the request that was sent to all employees who wanted to request working remotely.
Okay. And what was your understanding of when those requests were received?
I'm not sure when they were actually received, although I submitted it on October 13th, and that was likely the day that I was asked to do so.
And can you tell me what the significance of inactive employees are for this data?
So as of the date that this was exported from the system,
October 13th, right? 2025?
2025.
Is that correct?
I don't know off the top of my head what date this form was
Okay, so
exported.
maybe go back for me. So you generated this in October 13th of 2025, but when does this capture data from? Like, what point in time is this capturing when employees were performing telework? On October 13th or on another time?
So the date that I mentioned was October 13th, 2021. That was the date that's listed here. That was the date that the form was submitted into the system. I don't know what date this particular form was exported from the system.
Okay, I'm a dive here, so you'll have to explain it to me again. So when you were capturing this data, what point in time would this capture as far as what employees were actually working?
So the timestamp that is listed within each record, that is the date and time that the employee submitted this form into the system.
Right.
And so they were all active at that point in time. They were active employees. The active or inactive field, third from the right, indicates at the time that this was exported from the system, whether they were an active or inactive employee.
Okay, so I get that. So now when did you actually generate this shared form export?
I do not recall off the top of my head, but this is a complete export from the system, and the final form was submitted for this format in September 2025. So it would have been after that date to ensure that it included the full range of submissions.
I see. Okay, thank you for that.
Yes.
So there was no way to know how many employees were teleworking without filling out this form. Is that correct?
Objection foundation.
Whether or not it was reflected there, there's no way to know if there were others that would have been teleworking, but they just didn't fill out the form. And so they wouldn't be included in this document that you generated, correct?
Yes, this document is a full, complete list of the forms that were submitted into the system.
And
If I can just for clarity,
Yes.
is that as of October 13th, 2021, or the time that you actually exported?
As of the time it was exported. So each of these records, the date and timestamp, that just indicates when they submitted it
Uh-huh.
into the system. But the timestamps go all the way to September of 2025.
Yeah.
You're welcome.
So a question.
Yes.
So, this exhibit contains, a compilation based on requests that were submitted between 21 and 25.
Yes, that's correct.
Was sort of bracketed within that time frame.
Yes, the time frame is the first was submitted August 9th, 2021. And the final was submitted September 25th, 2025.
So were there some employees that didn't submit? Are there more that just didn't submit that form?
There are likely additional forms. There are likely additional employees. The state of Vermont currently has approximately 8,000 classified employees. And this is the number of submissions in here is above 7,000, but not 8,000. So I would interpret that as there were employees who did not submit a form.
And if an employee changed their work status between August of 21 and August of 25, would that employee still be listed here, or were there some employees who changed and were no longer teleworking, whose names might appear here?
If I'm interpreting your question correctly, I'm sorry, could you rephrase the question? So
If at some point between 2021 and 2025,
yes,
an employee changed her status
yes,
from telework to in the office,
yes.
would that be reflected here? Would that employee still appear here, or would she have been removed?
Yes, it would still appear within this list. Yes.
And so to piggyback off his question here, so if that change happened, would it necessarily be reflected as an update for this form? So if in 2024, the existing telework capture would have said 24 hours and then employee returned to the office another day, so that would be updated to then say 16 hours instead of 24?
It would only be updated if a new form was submitted.
Thank you. So now, if I'm understanding you right, the ZZ through OOO are the documents that were uploaded into the system, and that data within those documents was captured, and then that would enable you to automatically generate the numbers that are in YY. Is that correct?
Yes, that's correct.
Okay. And so are the documents contained in ZZ through OOO, do those constitute a complete accounting of any document that was uploaded? So this is all of the documents that were attached
No.
in that system. So tell me about why these documents. How did these did you pick them? I should say, did you pick out these agreements?
No, I did not.
Okay. And so do you know how many telework request forms were attached in this system?
I believe it was approximately 7,000, but I don't know the exact number.
So you cannot submit that this data would not be generated unless there was one of these uploaded forms. Is that correct?
That is correct.
Okay, so this paper Microsoft Word form, they don't have the mileage and the road trips or the mode of transportation. Isn't that correct?
That is correct. So if I can clarify.
Of course.
So in the form that the Microsoft form that was submitted is where those questions were asked, and it does not, this telework agreement was included as an attachment. The data that is listed in Exhibit YY is a combination of the PDF that was included, this telework request, and any values that were entered into that form. So it's a combination of the two.
Oh, so you're saying there was some additional information that may have been included with this telework request form?
Yes, there were additional questions that were asked in the Microsoft form that were not reflected on the PDF. And that is what is displayed in Exhibit YY.
So my understanding of your testimony was that this data from YY was pulled directly from the data that was entered in on these forms that were submitted, that this is not a complete accounting of all the forms, but of the all the forms that were attached, that data was pulled and put into this form. So I'm still confused. Is there an additional form that you compiled to get the transportation and round trip mileage, or
So I'll clarify. So the employee was directed to a Microsoft form where there was a series of questions, and it included those such as mode of transportation and round trip miles. And they completed the answers to those questions within the form, and they attached this completed form to their submission when it was sent into our database.
And so when would they have been prompted with those questions? At what point in the process?
When they went to the Microsoft form and submitted the form.
And uploaded the form?
Yes.
Okay. And so we can assume then that the telework form from 2021, at that time, they submitted that they drove by automobile and had X amount of time round trip.
Yes.
So is it true that each time then, if an employee needed to update their telework form, they would be prompted with those same questions?
Yes.
So then if someone had an existing telework form in 2021, but changed their telecommuting, they would not have necessarily, and they didn't update their form, then their current commuting mileage and mode of transportation may not be accurately reflected presently, unless they updated their form.
Correct.
So I see that there are some submission dates that appear to be done on this same day, only minutes apart. Do you recall if employees coordinated their submissions, or would there be another reason why they would have submitted these forms only minutes apart?
I really can't speak to the rationale for why they would have submitted them. I mean, the timestamps are the timestamps. It's the data that was submitted into the system. They may have made an immediate change to their form and resubmitted, but I really can't speak to why they would have submitted multiple forms back to back.
Let me just make sure that I'm looking at the right thing for the timestamp. So I'm looking at YY in the 7th column. Is that right?
Yes.
Okay. And so, isn't it true that that perhaps the supervisor in a written form might have integrated this data from a written form into and done it in batches?
Objection that calls for speculation.
If he knows, I mean, he doesn't know, doesn't he?
I really can't speak to what the employee did in terms of submitting data.
So you don't know whether or not it was a supervisor who entered the data off a paper form, isn't that right?
I'm sorry, can you clarify what you mean off of paper form? It was all submitted into the Microsoft form.
Are you aware of employees filling out a form in a different format other than digitally?
I am not aware of that.
And so in your review of the records, you've never seen a wet signature on any of these telework request forms?
I do not recall seeing one though.
Isn't it true that the state has now moved to a DocuSign format for their telework request forms?
I do not know the exact software that's used.
Okay. No further questions.
Redirect.
Yes, thank you. Just a couple of follow-up questions
Yes.
to clarify. So when Attorney Terrell was asking you about when you submitted a form or that type of thing, and you said October, I believe you testified October 13, 2021. Yes, October 13, 2021. Were you talking about when you submitted your own telework form and filled out the form?
Yes, that was my understanding of what the question was.
And when you said that, was that the direction of Harold? Were you talking about submitting your own telework form?
Yes, that was my understanding.
Thank you. And then I just want to kind of clarify where the data from that's in the spreadsheet comes from. So there was some discussion across about whether it comes from the PDF telework forms or if it's entered on this Microsoft form by the employee. So does any of the data, any of the information on the spreadsheet come directly from the telework forms that employees uploaded, or did they separately enter the data into the MS Microsoft form?
Correct, and thank you for that clarification. The data that is appearing on this spreadsheet is data that was submitted on the Microsoft form itself, and the employee attached a PDF to their submission.
And is there any information from those PDFs that's sort of directly extracted without human intervention to populate any of this spreadsheet?
No,
Thank you.
I apologize if there was a misunderstanding on that.
No, I just want to make sure we're all understanding.
Yes,
Thank you.
I do have a couple of redirects based on that. So, you had said that you didn't remember when you generated this form, but that it would have been after September of 2025 because that's the last date that's reflected in the column 7. Is that correct?
yes, that's correct.
Okay, so speaking about that task, about your task of generating this data, who
Yes.
directed you to generate this data?
And
Unless, and with the caveat that if it was an attorney, you don't have to say anything other than it was an attorney, right? So,
It was upon request from my leadership team to have a complete list of all of forms that had been submitted.
and did they give you a reason for that request?
Not specifically. My understanding was that it had been requested of them,
Okay,
and they were then in turn requesting us to pull the data.
and were there other aspects of the Microsoft form, which we don't have the copy of the Microsoft form that was made in addition to these PDFs. So I don't know what's on it.
If I could just, I'm sorry, just to avoid, I'm getting a little bit confused, just so that I'm going to ask the witness this question. So the PDF that's being referenced, that's the
Yes.
telework request form.
Correct. Yes.
And the Microsoft form is an additional form that employees were prompted to fill out when they submitted their telework request form.
Yes, that's correct. Yes.
And in that Microsoft form, what other questions were asked of employees that are not reflected here in this data?
All of the questions that were asked on the form appear in the columns in Exhibit YY.
Any further questions?
nothing further.
Thank you. You're excused.
Do
Thank you.
board members have
Oh,
questions?
sorry. Any questions? I have no questions. Michelle, questions?
I have none.
Sorry.
I just had one question. If
Yes.
the Microsoft form was not completed or filled out, did that prevent the telework request form from being processed?
No, it did not. It would have been sent with a blank value in any fields that were not completed.
So are there some telework, some of the names that are listed in YY? Is it possible that let me strike that. Are there additional employees that aren't listed in YY that are not included because they did not fill out that additional Microsoft form?
Exhibit YY only includes those employees who did submit a form,
And by form, you mean the
Microsoft form.
Okay.
Yes.
So YY, is it fair to say that YY may not include all employees who submitted a telework request form?
It is possible that employees submitted a form,
And
a paper form, within their departments, but this is a complete list of employees who did go into the Microsoft form and submit a form in that instance.
but if they only submitted the telework request form and not the Microsoft form?
Correct. They would not appear on this list.
Okay, thank you.
Yes.
Now,
Sorry.
Thank you.
I'm ready to go.
Okay. Thank you.
Thank you.
We would next call John Berard.
Hello? Mr. Berard, do you solemnly swear or affirm under pains or penalty of perjury that the testimony you shall give relative to the cause now under consideration shall be the truth, the whole truth, and nothing but the truth?
I do.
Welcome.
Thanks.
And could you please state your name for the record?
John Berard, Berard. Thank you.
And who is your current employer?
The State of Vermont Department of Human Resources,
How long have you worked for the state of Vermont Department of Human Resources?
21 years.
And what's your current role?
Director of Labor Relations.
What are the duties associated with that role?
Myself and my team assist with negotiating the successor collective bargaining agreements, interpreting those agreements and policies and procedures, providing guidance to all levels of employees within the executive branch of the state. And we also provide direct human resources support to the Vermont Veterans Home. We also provide day-to-day guidance on less than straightforward employment matters.
And how long have you been in this current role?
I've been the director since August of 2016.
What role were you in before that?
I was originally hired as a labor relations specialist and then was promoted to senior labor relations specialist and then became the director.
And what are the job duties associated with being senior labor relations specialist?
Similar to being the director with a smaller scope, you also conduct step 3 grievance meetings, provide day-to-day guidance. The role really just gets more expansive as you go up the chain.
And when did you become a senior labor relations specialist?
I don't actually remember.
And before you were a senior labor relations specialist, what were your duties as a labor relations specialist?
I, again, provided day-to-day guidance, provided interpretation of policies, procedures, collective bargaining agreements, assisted in negotiations, negotiated agreements that were not part of the successor agreements, but were like stipulated agreements and agreements between the union and the state regarding individual employees, for example. But also I was under the oversight of the director.
I'd like to start with Exhibit F. Turn to that reminder. F is in red. And if you recognize that document.
I do.
What is that document?
It's a copy of state policy 11.9, the telework policy.
And how are you familiar with that document?
I bargained it with VSEA
And when did you begin that bargaining process?
in October of 2011.
And how did that bargaining process begin?
Originally began from a request from the administration at that time to create a telework policy. And the question was, do we have to bargain it? The answer was yes. So I reached out to VSEA. I believe the interim director at the time was Connor Casey, and he delegated the task of bargaining to Michael Casey, who was the general counsel at the time at VSEA, and that's when the bargaining started.
And how did that proceed? How did you conduct the bargaining process?
Had a conversation with Michael first, and then submitted a draft proposed policy to VSEA for review. VSEA did whatever review they did with the bargaining teams. On their end, they submitted a counter proposal. We considered their counter proposal and rejected some of their proposed changes and adopted others. Typical negotiations. There was a back and a forth until we finally reached an agreement on what is the current telework policy.
And what bargaining units were involved in that process?
Non-management originally was the non-management unit and the supervisory unit. Started with non-management first, I believe.
And how did it, you said both non-management and supervisory unit, at what point did the supervisory unit become involved?
I think from our perspective, we believe them to always be involved, but the real question for them was originally as the policy was first proposed, you could have read it as a prohibition for any supervisors teleworking. And they wanted to have access to telework if it was available and possible. So we ultimately made a change to the policy that cleared up the concern about it being a complete prohibition for a supervisor to telework.
I'd like to ask you some questions about the policy itself, based on your knowledge of that bargaining process. As far as authority to approve a request to telework, who was given it? What was your understanding of who had that authority?
It's the appointing authority or their designee.
And what was the intent of that language regarding the appointing authority and their designee?
Well, when we bargained it, there was some conversation about who would have kind of final approval. The state was not interested in having that approval lie solely with a supervisor or even with a director, and they wanted to make sure that, remember that this was a new concept at the time for the state. We moved away from a no telework at all kind of approach to moving into a telework venue, and so there were concerns that decisions about telework would be made without real thought to what the impact on the operation might be. And so ultimately the decision was that the appointing authority would have to approve, or their designee would have to approve all telework requests. And
does an employee just have a single appointing authority, or could there be multiple appointing authorities applicable for a given employee?
Technically, right, an employee has a single appointing authority, but it's a chain of command. So that appointing authority. So I have a deputy commissioner. In my structure, I don't report to my deputy commissioner. I report to my commissioner. So there's deputy commissioner. There's a commissioner. There could be we're part of an agency, so we have a deputy secretary and a secretary of an agency, and then of course, right, it all ends at the governor.
And I'd like to talk a little bit about the paperwork associated with the telework policy. Was there any sort of paperwork that an employee was required to complete when requesting telework?
There's a telework form that's included with the policy. It's Bates stamp 16, F16.
As far as termination of a telework agreement, what were the provisions regarding that?
Any reason or no reason, subject to, if possible, a 2-week notice.
And who could initiate termination of a telework?
Either the employee or the employer.
And when we speak of that employer, who on behalf of the employer could do that?
Generally, it's going to be the appointing authority or their designee.
I'd like to next turn to the Flexible Working Arrangements Act. Are you familiar with that statute?
I am.
And are you familiar with the requirements under the statute?
I am.
How, if at all, did the Flexible Working Arrangements Act impact the telework policy?
It didn't. When the Flexible Arrangements Act was enacted, unartful, but we took a look at its requirements and believed that we were meeting the requirements through use of the telework, the existing telework policy, and the collective bargaining agreements have a provision that allow employees to request alternate work schedules, so schedules that are effectively individualized and non-standard. We believe that between the use of the telework policy to request telework and the alternate work schedule to request alternate work schedules, we were meeting the obligations set forth under the Act.
I'd next like to turn to the COVID pandemic. Were you involved with the state's response to the COVID pandemic?
From a labor relations perspective, yes.
And are you familiar with how that response impacted the state's use of telework?
Yes.
Now, what did the response entail as far as telework was concerned?
Well, ultimately, the decision was made by the governor, right, to have all employees effectively telework. So we all ended up working remotely under emergent circumstances. So we didn't make any changes to the telework policy for those reasons. It was an emergent circumstance in response to an extraordinary situation.
And were there any provisions of the telework policy that were temporarily waived when that emergency went into effect?
No, there were no real discussions regarding waiving of the telework policy. The discussions at the time were really focused on compensation for employees who might not otherwise be able to telework in the moment because they didn't have the equipment or their jobs didn't lend themselves to telework in any way, shape, or form. And so folks outside of the congregate care facilities like the correctional facilities or the psych hospital or the vet's home, for example, but we're talking about folks who worked at what we used to call rest areas, for example, right? We closed those folks can't telework. What are we going to do about that? And ultimately, the parties reached an agreement where they were going to continue to receive their full salaries.
And you spoke of the parties. Who were you referring to?
Oh, sorry, VSEA was the main partner there.
So were there discussions between the state and VSEA regarding those issues?
Oh, absolutely.
And I'd like to direct your attention to exhibit N as in north. And are you familiar with that document?
Yes.
And what does this document?
As I recall, it's a response from then the Secretary of Administration, Suzanne Young, to a letter that the administration received from Dave Bellini, who was the VSEA president at the time.
And were you aware of VSEA's concerns at the time?
Yes.
And what concerns did this letter seem to resolve?
I think the concern was the fact that I think the concern everybody had was, right, the safety and health of the employees and the public and everyone else due to the COVID pandemic. And so the governor had encouraged folks to continue teleworking, but also coming back to the office. And so the concern was, what is that going to look like? Is it going to be safe?
I'd like to next move forward in time to 2024. Are you familiar with the telework policies at the Department for Children and Families, specifically the Economic Services Division?
I'm not familiar with their telework policies. They're governed by the telework policy, the 11.9.
Thank you for that clarification. Are you aware that of any, strike that? I'd like to direct your attention to exhibit FF as in Frank,
2 Fs.
2 Fs.
So one wasn't enough. Too far.
Are you familiar with this document?
Yes.
And how did you become familiar with this?
It was forwarded to me from, I believe, then Commissioner Winters or his designee after he received it.
And why would he forward this to you?
Because I'm the Director of Labor Relations and it contains a demand to bargain. And those generally come to Labor Relations, generally though from the VSEA Director of Labor Relations.
And what was this demand to bargain regarding?
So the Economic Services Division of the Department for Children and Families had made a decision to suspend telework for certain of its employees in order to have them return to district offices.
And were you involved in discussions regarding that suspension of telework?
Only to the extent that I was asked whether the department had the discretion to do that. And if so, what would be the process?
And you described this letter as a demand to bargain. What was your response to this letter?
I drafted a response to the letter.
And I can direct you to exhibit GG as in travel. Is this the response that you're describing?
Yes. So I drafted a response to the letter, basically taking the position that we had already bargained over the ability of the department to suspend the telework policy because the policy itself allows telework at the sole discretion of the appointing authority.
Along with this, given that you declined to engage in further bargaining, did you engage in any discussions with VSEA?
Yeah, as a matter of practice, even if we are taking a position that something is not a mandatory subject to bargaining or at that time, or not subject to bargaining at that time, we, at least we, meaning me, as a general rule, offer to meet and discuss with the representative to hear employees' concerns or their concerns to see whether or not there is still some way to address whatever concerns the folks have. So that's it's in the next to last paragraph of the letter. It was an offer to meet without either party waiving any legal positions it might have regarding the matter. It's a standard approach.
And before turning to that meeting, I wanted to ask you, did VSEA at any point request any additional information regarding?
Yeah, it's originally in the letter that I called demand letter had a request for information in it as well.
And Did the state respond to that request?
Yeah, we provided that information.
Approximately what was said.
I think by the time we gathered that information, it was February of 25, I want to say.
And you were referencing a meeting with VSEA. When did that occur?
That also occurred in February of 2025.
And who all was involved in that?
It was myself, my team, just two people, representatives from Economic Services. It was the deputy commissioner, might have been their director of operations as well, and maybe one other. It was VSEA's director of labor relations, Gary Hoadley, impacted employees, and I don't recall if there were members of the bargaining teams on the call or not.
And what in general was discussed?
It was a Teams meeting. Sorry, I call it a call, but it was a Teams meeting.
And what in general was discussed at that meeting?
There was some discussion about the underlying reasons for the decision, and also a question of whether or not this was a permanent cessation of telework or whether it was a suspension, and whether there'd be the ability for employees to telework in the future, assuming things changed. That really was the kind of the extent of the conversation.
And at any point, did you receive a grievance or any other type of legal challenge to ESD's decision to
No.
suspend telework? I'd like to next turn to the 2025 Return to Work Initiative. Were you familiar with the governor's announcement of that initiative?
I'm familiar with the announcement he made, yes.
And what transpired after that announcement?
After the governor made his announcement, we began helping to plan and the implementation of his announcement.
And did you engage in any communications with VSEA regarding that initiative?
Yes, I believe I sent them notice of the intent in September of 2025.
And I'd like to direct your attention rather to Exhibit 15.
I'm sorry, what exhibit? I missed it.
Exhibit 15,
15,
one time.
thank you.
B? Yeah,
Yes.
yeah, it's on the back side. Sorry.
Is this the notice letter that you were referring to?
It is.
And what was the purpose of that communication?
It was exactly as stated, was seeking VSEA's input into the governor's decision, and to get input, identify concerns, try to ameliorate those concerns. Again, it's a very standard approach from our perspective, to seek input from stakeholders.
And was VSEA aware of the state's position at this point, that it was, again, implementing this pursuant to the state's telework policy?
I don't know if they were aware of it at that moment on the 12th. I mean, I think they're aware of the position that we don't have to bargain over it because we already have a telework policy in place. That's in the letter.
And did you receive a response from VSEA?
Yes.
And I'd like to direct your attention to Exhibit 19.
Yep, that would be the response I received.
And based on this response, what transpired after this? You received this response.
Ultimately, we ended up meeting with VSEA to really answer questions that they had regarding the governor's decision to return employees back to the office.
And who participated in that?
For the state, it was myself, my staff, so Shelley Morton, Labor Relations Manager, Jennifer Wendell, Labor Relations Specialist, and Douglas Farnham from the Agency of Administration. From VSEA, it was attorney Gordon O'Connell, Steve Howard was there, and then there were a number of folks from the bargaining teams.
And do you remember when that meeting occurred?
Not specifically, I don't.
And what was discussed at that meeting?
VSA had a number of questions relative to the governor's decision, the rationale behind it. So they asked questions related to that, and they expressed their displeasure with the governor's decision.
And I would like to next turn to exhibit 29, that's 29. And do you recognize this document?
I do. It's the formal demand to cease and desist and bargain over the changes.
And would you have received this before or after the meeting that you were describing?
I'd have to look at a calendar. I don't recall, actually. I'd have to look.
And at some point, did you provide a response to
They did.
this letter? And I'd like you to turn to exhibit 3333. Second page of that exhibit, first page. Do you recognize that document?
I do. It's my response to the previous letter.
And what was the substance of your response?
That because we had already bargained the telework policy and it was currently in place, that there was not a requirement to engage in what I would call midterm bargaining, and that if VSEA wanted to bargain changes to the telework policy or to include something in the collective bargaining agreement, that would be done during the current negotiations for successor agreements, which were ongoing at that time.
And those successor agreements, would those be the 2026 to 2028 agreements?
Correct.
And you referred to discussions that were ongoing at the time. Which bargaining units were involved in discussions?
At that time, we were actively engaged in negotiations with the non-management bargaining unit and the supervisory bargaining unit.
And without getting into the substance of any proposals, were there any proposals regarding telework made during those negotiations?
Yes, VSEA made proposals on remote work.
And what was the result of that proposal?
Those proposals were not part of the final agreement that the parties reached.
And you say the parties reached an agreement. Has the agreement been ratified?
Yes.
Just so we're clear, it's more than one agreement?
Yeah, it's supervisory and non-management.
Thank you. And they've both been ratified.
They were ratified at the end of December.
Thank you.
That's when we got notice that they were ratified towards the end of December.
I'd like to talk in a little bit more detail about the hybrid work standard. Are you familiar with that terminology?
Yes,
And what does that refer to?
it refers to the fact that the governor has instructed employees to return to the office, but has also at the same time said that he would allow employees to telework up to 2 days a week.
And which employees does that affect?
Impacts all executive branch employees who aren't currently meeting that hybrid standard.
Are there any situations where an employee might receive some sort of exception to that requirement?
Yes. So there are effectively two main paths to receiving what some would call an exception, right? The one is obviously that if an employee has a mental or physical impairment that substantially limits major life activity and they're considered to be.
Could you just pause for a second? I'm sorry, could everyone who's on this please mute themselves? Also.
Okay.
Thank you.
So if someone is effectively disabled within the meaning of the Americans with Disabilities Act or the Americans with Disabilities Amendments Act, they can obviously seek a reasonable accommodation, which may end up allowing them to work remotely in excess of the 2 days. And then the state implemented what's called the exception process, where employees could request to be accepted from the standard to telework or to be in the office 3 days a week.
And I'd like to take each of those in turn. For the Americans with Disabilities Act exceptions, were those handled under a new process or an existing?
No, it's an existing process, been in place since before I got to the state. So.
And the other process that you referred to, we've heard some testimony regarding an exceptions review team. Can you describe sort of that process and the team's role in that process?
Sure. The state created an exception request document. In fact, I think created an initial one and then got feedback and created a newer one. Ultimately, that request percolates kind of from the employee to a supervisor to their appointing authority to the exception, what's called the exception review team, and then ultimately to the Secretary of Administration.
And who all is on the exceptions?
Currently, it's Douglas Furnham and the Labor Relations Division, myself, Shelley Moore, and the Labor Relations Manager, and Jennifer Wendell, the Labor Relations Specialist.
And how does that team evaluate exception requests?
Based on the specific exception, so it's a case-by-case scenario. We review each one individually.
And could you provide just some examples of exceptions that
We've received requests for exceptions that run the gamut from employees who just don't want to have to go into the office to employees who have referenced transportation concerns, length of commute, child or elder care, personal medical needs. There's quite a variety.
and what happens while exception requests are still being considered within that process?
Employees continue to remain in their current status in both of those scenarios, both ADA and the exception request.
And by their current status, are you referring? Can you clarify what?
Sure. What I mean by current status means they're going to continue to work the current schedule. So if they're teleworking full time, they would continue to telework full time. If they were coming in the office 1 day a week, then they would continue to do that.
we've heard some testimony regarding what VSEA refers to as 3 pillars of the telework policy. And given your experience interpreting policy in your role as Director of Labor Relations, what's your perspective on whether the telework policy contains the following 3 pillars? And
Objection. His perspective on the VSEA's position is merely his speculation.
he is providing his understanding of the telework policy, and he drafted that policy.
That's not what he was asked.
I can rephrase.
Rephrase, please.
Is your understanding of the telework policy?
Objection leading.
What is your understanding of the telework policy with regard to control by local appointing authorities?
Well, I mean, from the local appointing authority. So what that means is that, right, each appointing authority is ultimately responsible for the operation of their department or agency. I mean, that's what I would interpret local control to mean. I mean, at the end of the day, though, it's all subject to the governor's direction from the standpoint of him being the kind of all caps appointing authority. He gets to set direction, and then appointing authorities are required to fall within that framework.
We've also heard discussion of case by case decisions. What is your understanding of the current implementation of the hybrid work standard with regard to case by case decisions?
Relative to exceptions?
Would exceptions be part of that?
Well, so the current telework policy, right, is being implemented from a standpoint of the governor has set the overarching approach, right, from a standpoint of telework is still permitted, right, but it's a maximum of 2 days per week. So an employee could come into the office 5 days a week if they wanted to, or telework 1 day a week. Those fall within the overarching parameters. But the governor, as I understand it, has instructed appointing authorities to determine how to apply that standard within their own operations to make it work. So from that perspective, a lot of appointing authorities have taken a look at their staffing versus their space or their operational needs to determine that there might be days that they would prefer employees to be in the office versus other days, but nothing prevents an employee from seeking a telework agreement or an alternate work schedule that is different than what the appointing authority is laying out, at least from a baseline.
And you referred a little bit to appointing authorities making adjustments as needed. Are appointing authorities able to implement a different number of days, for instance, requiring more days?
Certainly. Yeah, an appointing authority could have people come in 4 days a week or 5 days a week. A la ESD, for example, Economic Services Division.
So the final pillar, and I believe you touched on this, but I do want to address it, that we've heard spoken of in testimony, was arbitrary limitations on the number of telework days. What is your understanding with regard to the telework policy and whether how a limit on the number of telework days would apply under that.
It'll be up to the appointing authority, right, to decide what works for their business operations. And so in this case, the governor has determined what those limitations are going in the door.
That's all I have in terms of questions, but I did want to ask if you have anything additional that you would like to share with
Objection.
regarding this issue.
Objection.
Sustained.
Any further?
It's 10:30. Seems like a good time to take a break, use the facilities. Back in 10 minutes.
Okay.
Right? We're ready.
Thank you.
Again.
May I inquire?
Yes.
Morning. May I call you John?
You may.
Great. Let's start with the term appointing authority. That term is actually defined in the executive branch collective bargaining agreements, isn't that right?
It is.
And in those agreements, appointing authorities is defined at a level somewhat lower than the governor, correct?
That is correct.
You testified as to your familiarity with the flexible working arrangement statute. Did I have that right?
Yes.
You're aware, are you not, that the flexible working arrangement statute centers consideration on inconsistency with business operations, correct?
Yes.
And there is nothing in that statute that requires an employee to have any compelling reasons in order to have a flexible working arrangement, correct?
Correct.
I can skip right ahead to, so not going to skip so fast. Let's talk for a moment about the negotiations in 2011, 2012.
Okay.
And that was for the original telework agreement, correct?
Was for the existing telework policy.
11.9,
That's correct.
which you negotiated with the VSEA.
Correct.
And your negotiations started with a review with the non-management unit, correct?
Yes.
And then ultimately you moved on and had other conversations with people regarding the supervisory, right?
Yes.
Okay, so in terms of that policy itself, the policy from 2012, first of all, it doesn't contain a particular hybrid standard as to the number of days an employee has to be in the office, correct?
Correct.
And under the negotiated policy, employees could, and indeed did sometimes telework up to 5 days.
Correct.
And employees under the original telework policy did not have to show any compelling reasons to telework more than 2 days per week, correct?
Correct.
And then there was, as a result, no exceptions process because there was no cutoff standard, right?
Correct.
So employees didn't have to prove a need for an exception to a number of days because there was no set number of days.
There was no set number of days. Correct.
Okay, now I'm going to jump ahead to ESD.
Okay.
Were you involved at all in the decision of the Economic Services Division to curtail the telework arrangement for some of its employees?
Not in the decision itself, no.
You became aware in the communications after the decision had been rendered, is that right?
I became aware that they were planning to do it. Unfortunately, the timing was that ultimately they made the announcement just prior to when I was reaching out to VSEA to let them know. So the timing of the communication was less than optimal.
That's reflective of the timing of the communication in 2025 when the governor made an announcement before you had a chance to reach out to VSEA. Is that fair?
It's accurate.
So getting back to 2024 then, you testified about the union having requested information that the state ultimately provided. Do I have that right?
Yes,
And that was provided in or around February of 2025.
correct.
Did you review that information before it was provided to the VSEA?
Generally, yes.
And you were aware that it contained really hundreds of pages of concerns from constituents and legislators about the services being provided by ESD.
Yes,
And so those that information then contained some concern that telework was perhaps inconsistent with business operations for that group of employees.
well, I wasn't interpreting it, so, right.
Fair. Let's move on. You testified about a meeting that you participated in with the VSEA regarding the hybrid standard being implemented. Do you recall that meeting?
I do.
And so that meeting was sometime after the union's September 26th request for the meeting, right?
Correct.
And it was sometime before the union's demand for negotiations over that policy.
I believe that's accurate, yes.
Okay. So, and during that meeting, did you serve as the primary spokesperson for the state delegation?
I think I spoke probably the most, yeah.
And the union in that meeting did more than just express its displeasure at the governor's decision. The union actually had a number of questions, right?
I believe I testified to that, yes.
So the union asked you what information the governor was relying on when he made the announcement. Do you remember that question?
I do.
And your answer was that you were not aware.
That's correct.
The union asked whether there was any data supporting that everyday Vermonters had been negatively impacted in services provided by the state as a result of telework. Do you remember that question?
I do.
And you said you were not aware of any such data. Is that right?
Correct.
The union raised concern that there was not sufficient office space owned or leased by the state to return everyone to at that point. Isn't that right?
Yes.
The union asked whether there was any study about the environmental impact of returning all the commuters to the roads, right?
Correct.
And you were not aware of any such study, right?
Correct.
I believe you were asked that whether you had an estimate of the number of people who might leave state service as a result of this change. And I believe your response was that you had no solid estimate, that you had just heard some anecdotal things. Do you recall that?
I recall the question, and the answer seems correct, yes.
So in terms of anecdotal information that you had at that time, so we're talking early to mid-October last year, what kind of anecdotal information did you have about whether people might be leaving state service as a result of the change?
Anecdotally, we had just heard that some people might, so we didn't have a number. I didn't have a number.
Do you know whether that was part of the governor's decision-making in implementing this change to actually reduce the state workforce?
My understanding is it was not.
And where do you get that understanding from?
I got it from the Secretary of Administration.
During that meeting, the union also raised a concern about the lack of affordable housing near state work sites. Isn't that right?
That's correct.
And I believe by that point in time, the state had announced its guidance with regard to out-of-state employees. Do you recall that?
I don't remember what the timing was. It's possible.
Do you remember some conversation in that meeting about employees who had either taken state employment or moved their primary residence as a result of conversations with their supervisors about the ability of telework?
Yes,
And so these were all different concerns that the union raised at that meeting?
that is correct.
Let's talk for a moment about the exceptions request team. Who was responsible for choosing the members of that team?
I don't actually know, quite frankly.
Do you recall who told you that you would be on that team?
Douglas Farnham.
And remind us what Mr. Farnham's position is?
You know what? I don't know what his official title is, actually.
Can you just tell the board what his role has been with regard to the return?
He's been like the chief recovery officer was his title, I think, last I knew.
And what has been his role with regard to the return to commute?
Oh, he's been active in the team that was providing their input to the governor and the leadership team about return to commute. He's again on the exception review committee, and he also attended the meeting with VSEA.
So you've testified already as to who is on that committee, but can you remind us who's on the exceptions review team?
It's myself, Shelley Morton, who's a labor relations manager, Jennifer Wendell, who's a labor relations specialist, and Douglas Farnham.
So that team does not contain anyone from the various agencies that are impacted by the statewide hybrid standard?
Other than the agency of administration.
And what is the process that the team utilizes in reviewing requests?
We review the information that's submitted and we discuss it.
Among yourselves?
Yes.
Does the committee or the team, excuse me, seek out or elicit any further information either from the appointing authority or from the affected employee?
Depending on the circumstances, we have reached back out to get additional information. Yes.
And was that reach out to appointing authorities, to employees, or to both?
It could be both.
And has it been to one or the other? Or
generally more so to the employee to get more clarity based on the request.
And that would be clarity about what the employee has indicated were their compelling reasons for seeking an exception?
In most cases, that's correct. Yeah.
How many exception requests has the team approved thus far, if you know?
I don't know how many have been approved.
Do you have an approximate range?
I don't have an approximate range on that.
Has the team as of yet denied any exception requests?
So the team doesn't have the ability to approve or deny, right? We can only make recommendations for approval or denial to the secretary.
Has the team made any recommendations for denial to the secretary?
Yes.
About how many?
I don't know what the percentage is.
And so is it fair to say then that the team has recommended approval in some cases and denial in other cases at this point?
Yes.
And so those, whatever number it is that the team has recommended be denied, those are pending at the Secretary of Administration's office?
That's correct.
And you have no idea what that number is at this point?
I do not. We know approximately how many we've reviewed.
Do you know what, if anything, the Secretary of Administration is waiting for in terms of issuing those decisions?
I do not.
If an appointing authority denies an exception request, does that denial potentially come to your team for review?
Yes.
And has your team reviewed any situations where the appointing authority has denied the request initially?
Yes.
And has the team recommended overturning the lower level decision?
Yes.
I'm gonna ask a question I know you don't know the answer to, but can you
Sure.
tell me the number of such cases that you've recommended overturning?
Yeah, I cannot. I don't have a number.
Right, worth a shot. When's the last time your team met?
Last week.
Do we meet weekly?
Generally, yes, more than once a week. Depends on scheduling. We're trying to get through these.
And is there a standard that the team applies in deciding whether to recommend approval or denial of an exception request?
Yes,
What is that standard?
depending on whether or not it's inconsistent with business needs.
Does the team consider anything relating to whether the employee has demonstrated compelling circumstances justifying an exception?
That would be the inconsistent with business needs piece, right? Yes.
So an employee could potentially, I think you might have even testified to this, an employee could want to telecommute 5 days for no reason other than personal preference.
That is correct.
Right. If an employee had no reason other than personal preference to work telecommute 5 days.
Yeah.
Would that be sufficient compelling reason to allow that person to work from home 5 days?
No.
So you would require withdraw. So with regard to exceptions that have been approved, or let's keep it at your level, that have been recommended to the secretary for approval, what kinds of compelling circumstances has the team reviewed and determined were compelling enough to warrant an exception?
Off the top of my head, we have some time limited ones where individuals have certain medical conditions that are unresolved but are going to resolve, and then they're going to be able to meet the standard. We have requests where folks had no transportation and no availability for public transportation, but they were in the process of getting transportation, again, from a time limited standpoint. Kind of a number of variations of those type of items. There's been some very clear limitation that was being addressed.
Has the committee recommended approval of any time limited exceptions for employees who have a significantly long commute at this point?
Sorry, I'm thinking. Not specifically limited just to the commute. No.
Has the committee, the team recommended approval of any exceptions? Not time limit.
Nothing that's been open-ended in perpetuity, no.
Have there been certain requests that the team has recommended approval of that are time limited beyond June of 2026?
Yes.
What kinds of circumstances have allowed that?
Those the ones that I recall were very specific to, again, certain personal situations that were ultimately going to resolve potentially beyond June of 2026.
So then it's fair to say that the exceptions that your team has approved beyond or recommended approval beyond June of 2026 are all exceptions that you expected would resolve naturally within a certain period of time.
Yes.
So, John, the executive branch has 3 different collective bargaining agreements with the VSEA, is that right?
It does. Correct.
And there are certain differences among those contracts, but some of the provisions are actually identical, right?
Yes.
So let me ask you a few specific questions about some of the things contained in agreements between the parties. The wage rates, the state and the union negotiate over the wage rates and wage increases to be applied to bargaining unit employees, correct?
Yes,
And the governor does not have the right or the power to unilaterally lower any group of employees' wage rates, right? Because those are negotiated between the state and the union. Is that correct?
yes, it is.
The contracts contain vacation allowances for employees, correct?
Yes,
So after a certain number of years of service, an employee will get a certain amount of annual leave each year. Is that right?
that is correct.
And the governor has no power to unilaterally change the amount of vacation time an employee gets, right?
Correct.
Higher assignment pay. The NMU contract at least has higher assignment pay in it, right?
Yes,
And it has language in it describing who gets higher assignment pay under what circumstances, right?
yes,
And the governor has no power to unilaterally change who is entitled to higher assignment pay, correct?
correct.
And that's because the subject matters I just mentioned are fully negotiated subject matters that would require notice and an opportunity to bargain with the union before.
Yes.
That's all I have. Thank you, sir.
Just briefly, if I may. You were asked some questions about recommendations that the exception review team made to deny exception requests. I'd like to ask you how that process interacts with other types of requests, such as alternative work schedules or reasonable accommodation requests.
So if a request, an exception request comes in and it clearly is solely limited to the employee's mental or physical impairment, stated mental or physical impairment, then we were referring that actual exception back to what we would call the ADA process, right? So for the human resources folks who are assigned to support that agency or department to begin engaging in the interactive process that's required under the Americans with Disabilities Act and the Amendments Act to go through the ADA process to determine whether or not a reasonable and appropriate accommodation would be appropriate. So those are pretty straightforward. And then there are a number of other scenarios where, depending on what the request is, while the request itself may be inconsistent with business operations, the ability to have a discussion with the employee about an alternate work schedule might actually meet both parties' needs, meet the standard and the employee's ability to meet the standard. And so our recommendation also is including have a discussion with the appointing authority and the employee regarding the use of an alternate work schedule. Sometimes it's FMLA as well. So it's not as simple as this. It's not always as simple as a straight yay or nay recommendation.
Just one more thing to clarify. I believe you testified regarding sometimes the committee reaches back to the employee and or the appointing authority. Is there any other way for the appointing authority to provide information regarding an exception request to the committee?
So they can provide it on the front end, right? It goes to them before it comes to the committee. So they may provide along with their recommendation, right? So it's kind of a recommendation process upstream. And so the appointing authority has the ability to comment on the form.
Great, that's
No redirect or reprocessing.
Questions from the board?
I have a couple. I'm going back to that letter under tab 33. Because I am responding to your correspondence demanding to bargain over the state's decision to end existing telework agreements and requiring employees to return to their official duty stations. What is an official duty station? Because some of your employees have been teleworking and their official duty station since being hired has been in their home and they're teleworking 5 days a week and they've never been in an office. So what is to return to their official duty station mean for some of those people?
So every employee has an official duty station regardless of whether or not they may be teleworking full time. So my official duty station, for example, is 120 State Street. A lot of folks at the Agency of Human Services, their official duty station is someplace in Waterbury, generally the Waterbury State Office Complex. So, but every employee has to have an official duty station. And so we have some employees who are actually home-based as their official duty station, but not everybody who teleworks is home-based. And so someone who isn't home-based, who is teleworking, is still going to have an official duty station that they may be, under the telework policy, required to report to.
And my other question then is, in that telework policy, if telework was going to be stopped, it says telework is a voluntary program provided at the sole discretion of the appointing authority. It may be terminated by the employee or the employer without cause. Whenever feasible, either party provided a minimum of 2 weeks notice of the decision to terminate telework participation. What would that termination look like? Because as I've heard, it's a change in the policy rather than a termination that's going on right now. Because I would expect, as an employee, I would get a letter saying that this has been terminated and get my 2-week notice on it. And I didn't hear anyone telling us they've gotten that. So I'm wanting to understand what a termination.
Sure. If we were terminating telework, then we would provide notice depending on the circumstances, because this was for everybody, right? That was a generalized notice to employees, letting them know that they were going to be required to return to the office in December 1.
Excuse me, I'm just going to ask, although you're responding to her
I
question,
got to
just
speak up a little bit.
Thank
Sorry.
you very much.
Yep. It's
Thank
not
you.
a question. It's not a request I normally get, Judith, to speak up. Sorry. So, right, the notice here was a blanket notice as opposed to individualized because of the blanket nature of the termination of existing telework. The difference here is, and I think part of the confusion occasionally is, the governor, right, did two things. It was return employees back to the office, but also then at the same time say he was going to allow telework for up to 2 days a week. And so that's the hybrid standard. So as opposed to just saying, I'm bringing everybody back 5 days a week and letting the requests come organically, and providing guidance to appointing authority, say, as you get these requests, right, 2 days is acceptable. He went out front with that. He kind of built that in to the original announcement. So I think that's partly where the confusion lies here.
So you're
So
not really calling it a termination.
I would call it a termination of telework, but with effectively a new standard now that is acceptable operationally, right, for the state's operations. But it went out as a new hybrid standard right out the door, and because as I understand it, the governor recognized the fact that bringing everybody back 5 days a week was going to be unacceptable to some, right, and cause some angst and discontent. And he was looking for a middle-ish ground out of the gate, as opposed to saying everybody's got to come back 5 days a week. And so he effectively utilizing our discretion under the policy.
But that is a change to the policy.
I would argue it isn't, right, because telework is at the sole discretion of the appointing authorities.
I have a couple.
Go ahead.
Going back to the exception review committee, is that what it's called? Okay. So do you know how many of those exceptions are on your plate, or you have yet to review, the committee has yet to review?
I think we've got somewhere in the neighborhood of 600, and we've worked through about 400 or so.
And so those 400, you've made a decision whether to grant an exception or not grant an exception, or grant the appeal of the appointing authority, or
No,
deny the appeal of the
No, what we're doing is we're making a recommendation to the secretary. So we're not making a decision in
Sure.
granting or denial.
But you've made recommendations on whether to, you recommending granting the exception. That's one of the decisions your committee has made.
Yes,
You've made decisions whether to deny an exception.
yes,
You've made decisions whether to grant an appeal of an appointing authority's decision.
It's not really an appeal. It's just our recommendation is different than what potentially the appointing authority's recommendation was.
So if an appointing authority denied the employee's request, does the employee file, does it automatically come to you, or does the employee have to initiate something to send it to
No,
you?
it's supposed to automatically come to us. All exceptions, whether they're recommended at the lower level for approval or denial, are still supposed to flow to the committee.
Okay, thank you for that clarification. And you had said, just in terms of the standard that you applied when making your recommendation with respect to reviewing, sorry, let me just find my notes, is whether it's consistent with business needs,
Business operations, yep.
business operations. How do you make that determination? Is if you don't have someone from the particular agency or department, how do you know what the business need is?
Well, the standard business operation here that we are looking at, right, is the in this case for the exceptions review is the hybrid work standard as being the operations piece that we're looking at there.
Oh, okay. So the business operation itself is the hybrid work standard.
That we're looking at, yes.
Okay, so there isn't a subset. So it's whether or not they conform or don't conform to the hybrid work standard.
That's correct.
So there's not a sub determination of, okay, we're going to see whether their exception is consistent with a business, some other business need, like the ESD situation.
Right, that would be up to that appointing authority to decide, for example, that, right, they could put it in the comments, right, that this person needs to be in the office 5 days a week, let's say, due to operational needs. And we would consider that, obviously. So that would be kind of, again, if you think of it globally, the global overarching parameter is the hybrid work standard. And then below that, appointing authorities can have people in the office more often if they want to.
Okay. Did you ever become aware of why the governor made the decision to terminate or to make the decision to require folks to come back to work 5 days a week?
I got the same email message that everybody did.
Okay.
The video message.
Okay, thanks. I'm just going through my notes, sorry. And how many meetings has your committee held, the exception review committee?
I'm not actually sure because I was out for a little bit. Trying to think. Probably an average of probably 2 weeks since early December.
Okay, and so when you were out, did the committee go forward without you?
Yeah.
Okay, so does anyone step in your place to take your?
There's 4 of us, so
Okay.
at the end of the day, if somebody can't be there because they have a different commitment, then the meeting just moves forward.
And okay, and how many need to say yay or nay for your recommendations?
It's not really a vote. We generally get there by consensus.
There was a question asked around the time early to mid-October. I think it might have been in connection with the meeting that you had with VSEA, whether it was part of the governor's decision-making to reduce the workforce, the anecdotal information. And you said you heard anecdotal information, heard anecdotal information that some folk might leave, that you heard that from the secretary of the AOA?
No, I think the question was more about the nefarious plot, that this was an attempt to downsize state government in some fashion.
Okay.
My words, nefarious plot, not Attorney Gordon's. Right. And so I had heard from the secretary that that was just complete speculation, and not accurate in any way, shape, or form. That was that part of the
Okay,
conversation.
but the anecdotal information.
Anecdotally, I was asked at the meeting whether or not, I was asked at the meeting whether or not I knew if any state employees were going to leave employment because of the return to office mandate. And I had said that anecdotally, I had heard that some people were talking about it, but that I didn't have any numbers.
Okay. And from whom did you hear?
We heard it from different different employees or appointing authorities.
Thank you for that clarification.
Yep.
Just a few more. And can an appointing authority approve less than, strike that? So in October, Exhibit 29 is the letter from VSEA. And then there was a response by you on November 10th. I'm just,
Hold on, I've got to look.
Or,
There were more than one. There was more than one letter and one response.
I think Exhibit 29 is the October 24th letter.
Yep.
Yeah, my notes are right. Okay, so that was October 24th letter from Attorney Gordon O'Connell. A demand letter, and then you responded on November 10th, which I think is exhibits
33, maybe?
Yeah, 33. Thank you, which is November 10th.
Correct.
Okay, so I'm just curious why the reason for it taking a couple of weeks to respond.
Because we had internal conversation about it.
Okay. Were you contacted before the governor's announcement in August about the nature of the announcement?
No.
That's all I have. Thank you.
Michelle, questions?
No further questions.
I have a couple. Is it fair to say that the creation of the hybrid work standard was a modification of the work from home policy?
I don't see it, again, I don't really see it as a modification. I see it as an exercising the employer's discretion that was specifically built into the agreement. So I don't see it as a modification of the policy itself,
It was built into the agreement
the telework policy.
of the
Sorry.
telework policy at the provision that said that it may be terminated.
Well, it's at the, if you look at, I can't remember what exhibit the policy.
Yeah, this in front.
Thank you. F.
Too many Fs.
There are too many Fs, is right. Hold on, I'll get there.
The Dr.
I'm gonna have to get
Seuss.
shoulder surgery after this.
There's a too many Daves. Yes.
So when you look at the policy, one of the things that the state was really clear to do is maintain its discretion in its ability to provide telework. So when you look at, right, telework is a voluntary program provided at the sole discretion of the appointing authority. And that was a conscious decision by the state at the time, because especially at the time that the telework policy was created, not all appointing authorities were in favor of the idea of telework, and they wanted to be able to say no if they wanted to say no. And so we built complete discretion into the policy from our perspective. So I don't really see it as a modification, but a use of the state's discretion.
There was also discretion built in on the part of the employee as well. Is that not the case?
To request telework, yeah.
And to
terminate it if they wanted to, sure.
In regard to the work of the exception review team, I think in answer to Ms. Dillon's question, you told me that that team operates by consensus.
That's correct.
And then sort of walk me through the process. The consensus-based decision of the team goes to
The Secretary of
the
Administration.
Secretary of Administration, who has ultimate authority.
Yes.
And you said there were two pathways to exceptions, one being a request for an exception and the other being the ADA.
Correct.
But the ADA and the provisions found in the ADA predates certainly the hybrid work standard and as well the notion of telework by the policy we just looked at.
Oh, absolutely. It's not a new
So it's
process.
not a new, it's not, that's what I wanted to
Yeah,
clarify.
no. There's no
Yeah.
new process there. Again, I think using the word exception in both places causes some confusion, right? But well, if we're seeing an exception request that comes through and it is solely related to a mental or physical impairment, then that's really, right, that's a request for reasonable accommodation.
And are those still an ADA request? Is that reviewed by the team that we were just discussing, or?
No, we would refer that back to what I would call our normal ADA process.
So the exceptions review team only reviews requests or exceptions to the hybrid work standard.
That are not related to what are clearly an ADA request.
It simply
Yeah.
gets referred out and.
Yeah, and we have seen requests, exception review requests that are both. So they might have a component that is an ADA piece and a component that is unrelated. And so we'll refer back the ADA piece. And then we're actually holding the non-ADA piece, basically, I want to call it subservient, but we're going to wait to see what the outcome of the ADA piece is. Because if the ADA piece creates an accommodation that allows the person to telework in a fashion that they've requested, then the exception becomes moot.
I think I understand. There must be instances where ADA accommodations were in place prior to the telework situations that we're talking about.
That is correct.
No more questions.
I just had one more that I'm sorry I didn't. So the June 1st timeframe, what was the reasoning behind having June 1st as the date? A number of the exceptions.
June 30th.
June 30th. Thank you very much for
Sorry,
that clarification.
I think the only significance there, it's the end of the fiscal year.
Okay. And in terms of the limited, are all of the exceptions limited? Would all of the exceptions be limited limited by the amount of time it takes someone to comply with the standard?
No, I think the question really is, I think when we were talking about limited or time limited was about an answer to attorney.
Yeah, could you answer my question?
Yeah, I guess, can you ask it again?
Sure.
Then? Sure.
So the exceptions,
Yes.
if there are a number of folks who are applying for exceptions, and there's, at least looking at some of the documents, there's a time limit on the exception, June 30th, 2026. And so my question is in conducting your review of whether to grant or not grant an exception, you're looking at whether or not this particular person needs more time to comply with the standard, the hybrid work standard.
That's one of the factors. Yes.
Okay. So is there a possibility of someone applying for an exception that, they might have for whatever reason, new infant that's not going to go to school for 5 years, some other reason that it's going to take more than 5 or 6 months to comply with the hybrid work standard, where they would get a grant of an exception that it went beyond June 30th, 2026?
The answer is yes. You have to remember, the requests for exceptions are not all about ultimately meeting the standard. Some folks are just requesting exceptions from the standard completely.
Mhm.
Right. And so some of those requests are made for dates that are beyond, June 30th.
So there would never be a compelling reason for someone to be granted an exception if their reason doesn't allow them to comply with the hybrid work standard.
No, I don't think that's an accurate statement.
Okay. So, all right. Have you made recommendations for granting exceptions that go beyond June 30th, 2026?
Yeah, I believe I asked and answered that.
And you don't know the status of those, whether they've,
I don't,
okay.
I admittedly, to the extent that approvals have already gone out, I don't know for sure. I think some have, but given volumes of the work and just everyday pressures of other work, kind of once they've moved up the chain of command for review, unless it comes back to me for some reason, I'm moving on.
So you don't receive notification just kind of as a follow-up or whatever from the Secretary of Administration, we've denied or granted, or we've accepted your recommendation and that's not part of the process?
I have not seen any of that.
Okay, thank you.
I have one more question then. If an employee gets denied and we're already into that time zone where they should be back at work part-time, is it the next day they have to be back at work, or is there a certain amount of time they have to make that transition?
Yeah, so I don't know that that's happened yet at all, but my understanding is that folks are going to get at least 2 weeks notice to make the change. It's consistent with other language in the collective bargaining agreement about schedule changes.
They go first, then you go.
Do the employees know that?
I'd have to look at the the most recent version of the FAQs to see whether or not that was pushed out. This has been a little bit like COVID, where things have been very fluid based on feedback. So I'd have to actually
I
look
think
to
we've got
see.
some of that.
Yeah, 62.
You always back, didn't it? I can say that that's what's been discussed. I don't know what's been pushed out yet. Oh, thank you so much. Let's see. It's got updated while I was out.
Just not this one.
Yeah.
It's 62.
62.
3.
62.
We-
Might not have got that, actually may not have been pushed out yet. I can tell you conceptually, that's what the discussions have been. Thank you. Of course. There's been a lot of communications that have gone out.
I'm sorry.
Yeah.
What?
I said there's been a lot of communications that have gone out, various formats.
They've got a chance. to
Yeah.
go there.
That constantly changing stuff is.
Yes, it is.
Okay.
That makes
Attorney Kelly.
questions. You were asked about time limited extensions or exceptions. If an employee comes to the end of a time limited exception, is there any mechanism for the employee to request an extension?
They could effectively make another exception request or resubmit an exception request.
And would the process be the same for that?
I don't know that that's actually been determined yet. So can't definitively answer that.
And I would like to direct your attention to Exhibit 30 briefly. Second page of that exhibit specifically. And under the heading Action Needed Telework Requests and Agreement, you'll just read to yourself the second paragraph.
Okay.
And so I know you've gotten some questions about whether the policy was rescinded versus, individual telework arrangements. So can you speak to what the action was in terms of hybrid work standard? Did that affect the policy or telework agreements or something else?
Sorry, I don't understand the question, Chris.
So when that paragraph refers to the state of telework agreements after December 1st, what was the effect of that?
Well, I mean, it says what it says, right? It was effectively all telework agreements were rescinded, so ended, and you had to submit a new request.
And the telework policy, section 11.9. What was the status of that as of December 1st?
It remains unchanged.
Thank you.
Just a few things. Member Peters had asked you what it might look like if an appointing authority under regular circumstances was going to suspend or deny telework for a group of employees. Can you turn to exhibit EE?
Can. Okay. Oh, wait, that's the wrong one. That's FF. Sorry.
So what we're looking at is an email to ESD district office staff from Deputy Commissioner Miranda Gray. Is that right?
Yes.
And in the first paragraph of her message, she indicates to the employees that they had made a decision to suspend teleworking for a certain number of employees, certain offices in certain job titles, correct?
Yes.
So that is an example of a local appointing authority suspending telework for a particularized group of employees.
Yes.
And this email is dated October 18th, and Deputy Commissioner Gray indicated the change would happen on November 4th. So that's meets the 2-week requirement. Yes.
Yes.
The other question I have for you is in response to something that Executive Director Dillon had asked you about the significance of the June 2026 deadline for exceptions. I'm curious whether you are aware what the rationale was for setting December 1st as the deadline for the return to in-person work 3 days a week.
I do not.
That's all I have.
Well, those sides. Are we finished with Mr. Berard?
Yes.
Thank you, Mr. Berard.
Thank you.
You're welcome. Thank you.
Okay.
See if they've got rebuttal or any other
Any
witnesses.
further witnesses from either party?
That concludes the state's presentation.
Stay rests.
And the union has no rebuttal.
Calendar.
So we're adjourned. Yeah, okay. So in terms of briefing, we've begun to ask for the transcripts in this matter. And so hopefully within the next couple of days to early, where are we, Tuesday to early, next week at the latest, you should have them. So what, 2 weeks from the time that you get the transcripts, what's the time frame the parties are requesting for briefing? I mean, the board would prefer shorter, but we appreciate that there's a lot of materials here. So
The union suggested at the outset that while we would prefer a 2-week briefing schedule, in the intervening 2 weeks, it will be a school vacation week, both where I live and where Attorney Turrell
Okay.
lives and where counsel across the table lives. So we would suggest a 3-week deadline for filing briefs.
from the time that you get the transcript or from today?
I was thinking 3 weeks from today, but could be convinced different.
I will take notice, though, that it is town meeting
Yeah,
day on
it would-
Thursday.
It would be the 4th or,
Right.
so the 4th, is that what you're suggesting?
That is the union's suggestion.
What does the state think?
State, we agree.
Okay,
March 4th.
March 4th,
March 4th.
great. And they obviously could be filed electronically. As soon as we get the transcripts, we'll likely, if it's okay, feed them to you as they're completed, because the one from last week, that one's, we just received the draft, so it's likely you'll get that in the next day or so. If that makes sense to feed them out as we receive them.
Yeah, that would be great.
Anything else? Anything else that the parties need or no? Okay, great.
I think we're
Okay,
done.
yeah, well, thank you very much.
Thank you all. Michelle will stay for a bit.
Member Phelps.
Thank you.
Thank you.